Hi, good afternoon, Virginia, and congratulations on making it to the final round. That's a tremendous accomplishment. My name is Ben Glickman. I'm an attorney with the California Attorney General's Office. I'm also an alumnus of this program. I was on a nationals team way back in 1995. So we're going to have a good conversation today. If we manage to stump you, just hold real still and we'll think the Zoom froze.
How you doing? It's Hank Chambers, law professor from the University of Richmond. So some of you I've seen before. Good to see you all this morning. Of course, what Judge Glickman didn't notice that his team actually won the competition. He wasn't just hanging around, but he's too modest to say that, so I said it for him.
My name is David Hudson. I'm a First Amendment Fellow with the Freedom Forum Institute and teach law at Belmont University College of Law in Nashville, Tennessee, and look forward to having a conversation with you.
If you would please introduce yourselves and your teacher.
Hi, my name is Bella Stevens.
Hi, I'm Eliza Blue.
Hello, I'm Centil Mayapin.
Hi, I'm Kapil Iyer. We are Unit 5 from Maggie Walker, and this is our sponsor, Mr. Olmschneider.
Right, well, thank you and congratulations again on being here. If you're ready, I'll read the question and we'll get going. Today we chose question 1. A result of the decision in Wisconsin v. Yoder is that any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? Whenever you're ready.
Quote, "The purpose of separation of church and state is to keep forever from these shores the ceaseless strife that has soaked the soil of Europe in blood for centuries," end quote. As articulated here by James Madison, the concept of personal religious freedom has been instilled in Americans since the creation of the Republic. Religious life in the United States is largely left untouched by the government, allowing for a greater plurality of religion. This uniquely American religious pluralism is supported by 2 coexisting religion clauses in the First Amendment, the freedom of exercise and the freedom from establishment.
The Free Exercise Clause's purpose is to ensure that religious Americans retain the right to practice and believe freely. Traditionally, the court has used strict scrutiny to evaluate limits on free exercise, such as in Sherbert v. Verner. As demonstrated in this case, regulations of a right under strict scrutiny must meet a compelling state interest, a narrowly tailored application, and must be the least restrictive means of doing so.
The ideas explored in Sherbert were modified in Employment Division v. Smith, which permitted restrictions on religious action given a, quote, neutral law of general applicability. This case employed a belief-action dichotomy reminiscent of Reynolds v. U.S. and shifted away from Sherbert's accommodation doctrine. With the new test of neutral general applicability, Smith greatly reduced plausible religious exemptions, a large majority of which gave unfair advantages to certain religious individuals.
One area where both Smith and Sherbert uphold restrictions on free exercise is in the protection of public health. For example, during the COVID-19 pandemic, many states across the country placed restrictions on religious services. In May of 2020, the court ruled in favor of the governor of California's restrictions on churches in South Bay v. Newsom. But in November, the court switched sides in Roman Catholic Diocese v. Cuomo. While the court supported delegating the regulation of public health to the states, they found that Governor Cuomo's restrictions reached the point of targeting religious institutions, undermining free exercise.
Additionally, the Free Exercise Clause is often at play with public education, which is a right in all state constitutions, but not the national one. Griffin v. Prince Edward County ruled that states could not close public schools with the intent of denying education to a group based on race, but San Antonio versus Rodriguez concluded that the Equal Protection Clause did not create an absolute right to an education. Still, a constitutional right to an education is best found in the First, Fourth, Fifth, and Ninth Amendments, because an educated citizenry that understands these amendments is absolutely necessary to the operation of them.
For example, the Takings Clause is useless if an uneducated citizenry is unaware of its protections. As proof of this, Washington and Madison championed a nationally established university to build an educated citizenry. Thus, while the search for a right to an education in the 14th Amendment has been unclear, the perpetuation of our constitutional democracy necessitates a right to education.
In Wisconsin v. Yoder, the right to education came into direct conflict with the religion clauses. The court struck down K through 12 compulsory schooling laws after the Amish contended that their religion prescribes the removal of children from school after the 8th grade to go work on family farms. The court found that the state interests of having an educated populace and preventing child labor weren't compelling enough to justify the burden on their free exercise of religion.
In considering only the interests of the parents in the state, the Yoder court deprived children of their 14th Amendment substantive right of liberty to experience all dimensions of life through education and then independently discern their own religious conviction. Parents do have fundamental controls over children, but children evidently have a set of protections for their own rights. For example, Prince v. Massachusetts held that restrictions on child labor are constitutional in the interest of the child's 14th Amendment rights to life and liberty. This was true even when the labor was religiously justified, because, as Justice Rutledge wrote in the majority opinion, parents may be free to become martyrs themselves, but it does not follow that they are free to make martyrs of their children before they are old enough to make that choice for themselves. Thank you, judges, and we are ready for your questions.
Great, thank you. So I wanted to pick up on the COVID restrictions. So Roman Catholic Diocese was not the Supreme Court's last word in this area. And I guess I want to hear your views. Can a state enact a policy that says groups over a certain size need to be limited during the pandemic? And can it then apply that policy to churches?
I do believe that they can. For example, while this case didn't directly relate to religion, and Jacobson v. Massachusetts did deal with the vaccine, and the Supreme Court did rule that states should be responsible for all public health regulations, because I don't think that the Supreme Court is exactly expertise in the area of public health and know exactly what the requirements should or should not be for when a pandemic breaks out. So they should leave that to state health officials.
I think what's also really important is the nature of the activity in these institutions. What a government may try to do, or what the legislature may try to do, is to impose different restrictions based on the institution. If the restriction has only the primary purpose of inhibiting people from attending a religious institution, then that would be unconstitutional. But if they do that for the secular reason of, I don't know, singing or anything else that has more propensity to spread the coronavirus versus some other institution, then that would be more reasonable.
Well, let's take a concrete example. Just a couple of weeks ago, the court held that California's law that limited gatherings in your house. So it said no one can have a gathering in your home over three that has more than 3 households. And it said that because that applied to religious or Bible study gatherings, that it violated free exercise clause. How do you square that with what you just said?
Right. So the way the court evaluated this in the California case, as well as the Cuomo case, is by saying that in the Cuomo and the New York restrictions, the restrictions placed by the governor disproportionately affected religious institutions over other ones. But in California, Judge, the example you brought up, it's not necessarily true that churches were held at an unfair disadvantage over other institutions, such as, for example, meeting up at normal educational buildings or in homes of private homes as well.
Furthermore, in the decision for that case, they compared a lot of private meetings for Bible studies and other religious purposes to the lack of restrictions on supermarkets and other essential businesses like that. And I think that in this circumstance, it's comparing apples to oranges, because private gatherings, whether they be religious or secular, hold a different interest than the interest of supermarkets and other essential businesses, because of the fact that they're providing something that, we can't restrict in a time of COVID.
So let me switch gears for a moment. How would you guarantee a right to an equal education if the right to an education existed under the federal Constitution?
So one way would obviously be through in correlation with the Equal Protection Clause. Now, we do mention in our opening speech that Rodriguez shut down this argument that the 14th Amendment doesn't have a right to an education. But recently, in lower federal court cases such as Gary B. v. Snyder and Gary B. v. Whitmer, the federal courts ruled in direct contrast to Rodriguez, arguing that there is a right to an education in the 14th Amendment that can be litigated to provide equal education. The reason being that today, as our country becomes more diversified and ethnic minorities often face greater struggles to receiving equal education, a quote, absolute denial of education permits the judiciary to find a right to an education in the 14th Amendment.
Additionally, because many state constitutions already have an existing right to an education, we have seen how they've been able to extract an equal right to an education in certain states. And I think that if we had a written right to an education in the National Bill of Rights, it would have the same effect.
Exactly. We can actually look to the different state constitutions, their varying levels of equality of education. In the states that have more equality of education, you can see that there's standards of quality, which are legislative supplements to the right of education in the Constitution, tend to not give a floor for the, like a minimum for how the education requirement can be met, but rather an equality requirement that you have to meet all these different requirements that are just listed out in order to make sure that everybody in the state, no matter where they are, will have access to the same things.
To clarify what my colleague said, in the state of Virginia, for example, they have a set of legislation called the Standards of Quality that do lay out the bare minimum and the standards on which Virginia local or Virginia public schools must operate.
Okay, y'all argue that an educated populace is necessary in order to run a country. Should folks who are uneducated not be allowed to vote?
No, while an educated populace is certainly necessary in preserving the country and the Constitution, we're mainly arguing that a right to education is necessary to help those people vote. So once a right to education has been established and every single person has been able to have that education, then that would be no longer a concern. Also, people who don't have an education are still, the politics still do affect them. So it would be wrong to take that away when they still have a part to play in the government.
I actually think that theoretically, we ought to have the most educated people only be the ones who are voting. However, in practice, this is impossible to do fairly. I mean, we outlawed literacy tests in 1965 with the Voting Rights Act because we realized that no matter how, if we give the government the power to decide who is educated and who is not educated, it will inevitably create biases, whether that's based on race, sex, or any other way to marginalize minority groups.
I think additionally, it's not just that people who don't have the same level of education as other individuals shouldn't be able to vote. I don't think that at all. But I think that it would be much more helpful for them in understanding the rights that they possess and being able to use them if they're violated and understanding when they're violated, if they were to be more educated. And that's why a right to an education is so important.
And what my previous
how do we balance the rights of free exercise and the establishment clauses in the public school context?
Well, I would argue that we balance it in a way that it's secular. So, for example, in Engel v. Vitale, the student prayer was banned because it violated the Establishment Clause. And there's a difference between teaching religion and teaching about religion. So while some might argue that not being able to have school prayer violates free exercise in schools, I think that we need to look at it in a secular context. So having school prayer is teaching religion and would be inhibiting or promoting religion and enforcing it on people. However, teaching about religion in a secular way that is balanced and would be, for example, teaching the Bible as literature would be a way to allow for a religion in schools.
I think the key to that, go ahead.
Much of what my colleague has stated is part of the Lemon test established in 1971, where statutes must be tested if they have secular legislative purpose, primary effect that neither promotes nor inhibits religion, and must not foster excessive government entanglement with religion. But this is particularly a difficult issue inside of educational institutions because we care about the right of students to exercise their religion. So we've also developed a series of other tests, such as in Levy-Weissman. The prevailing test was one of non-coercion. In this case, that meant that a key part of school life, such as a non-elective class or graduation ceremony, absolutely cannot contain religious activity. But there are also many other tests, such as Sandra Day O'Connor's religious endorsement test, which argues that if the free exercise of students sends a message to non-adherents that they're outsiders, not full members of the political community, then the Establishment Clause is also violated.
I think furthermore that we could look at the exercise or the issue of free exercise in schools the same way that we look at the issue of free speech in schools. In Tinker versus Des Moines, which was a speech case, it was decided that schools have a compelling state interest in protecting the students' education, and therefore they can limit speech in circumstances which it's disrupting the educational environment. I think that free exercise can be seen in the same light, whereas if the presence of a religious practice or religious teaching, not necessarily teaching, but discussion of religion in a teaching environment is interrupting the educational value that that environment has, that's a circumstance in which religion can be restricted.
Thanks. We're almost out of time, but I think I heard you say that you could find support for the right to education in the Fourth Amendment. Can you explain that to me?
Absolutely. So we included several other amendments as well as including the first as well and the fifth. And this is because that these amendments have very specific wordings in their provisions that require education for the citizenry to understand it. George Washington explains in his first annual message to Congress that if there's no education, then these amendments basically become useless because the citizenry cannot determine if their rights are being protected or if the government is being arbitrary and unjust.
Thank you.
Great job. We'd like to recognize the students for their hard work and participation.
All right, we'll give you some feedback now. Do my colleagues want to chime in?
Sure, I'll jump in. Not surprisingly, very good opening. You provided a nice structure for how you wanted to deal with these particular issues. So that much I certainly appreciate. When we got into the Q&A, y'all had a lot of good answers, not too terribly long. Or I should say not too long. They were the proper length, which can be very difficult. I thought a lot of your examples were pretty darn good. They were recent as well, and that's the reason why I certainly did appreciate the conversation. The last piece about the Fourth Amendment question, that's one that I kind of wanted to hear a little bit more about, right? In part in terms of what the role of a lack of education was about. And I think y'all handled those questions really well. So appreciate the conversation, and I'll turn it over to my fellow judges.
Yeah, I agree. I thought it was really a great opening presentation. I love the ceaseless strife quote from James Madison as an introduction. And I thought that the structure and the way you connected Reynolds with Employment Division v. Smith showed that you had really almost absolute command of how the courts have vacillated in calibrating the balance when it comes to free exercise versus other rights. And that I thought that nuanced understanding also showed itself in the follow-up section where you really had, I think you showed a lot of nuance, and we really had a conversation. I just wish it could have been longer. As far as any little tips for edification, when I asked the question about how to balance the two religious liberty clauses in the public school context, one additional piece you might introduce is the Equal Access Act, which was a law passed by Congress, I think back in 1984, that essentially gives students the right to participate in religious clubs and other clubs, et cetera, under certain circumstances. And then when you mention Tinker, I might make sure to mention substantially disruptive. Some of the free speech advocates in the student realm emphasize it's not just any disruption, it has to be substantial. But I just thought this was an awesome performance, and I commend you so much, and I hope all of you will continue your study and appreciation of the Constitution. Thank you very much.
Yeah, I don't have a lot to add. I echo my colleagues' comments. I appreciated our discussion of the COVID restrictions. You clearly had followed that case law. You mentioned Jacobson, which my state and others relied heavily on early in the pandemic, and then the Supreme Court told us to stop talking about it. So we did. And then you were able to talk about the most recent decision in Tandon and some of the challenges I think that decision raises, where it's comparing, as you said, apples to oranges, some would say. And I think that opens up a whole host of questions that the court's going to be having to grapple with going forward about when does protecting free exercise go too far, and end up becoming an endorsement of religion of sorts. So I think those are great topics. Whatever we threw at you, you had a response and you had support to back it up. So I appreciated that. And you also had like, I don't know how to phrase it, but like a practical understanding of you weren't just talking theoretically. You were saying, yeah, there's this, but in practice, it's a problem for X, Y, and Z reasons, or in practice, it's going to be challenging for these reasons. And I appreciated that because it's easy to sit in our ivory towers and think of how things should be without really regard to how that would actually be implemented. So I appreciate that. Best of luck going forward.
Thank you so much,
so
judges.
much.
We appreciate you taking your time out of the day to judge us.
So much.
Congratulations again.